Joining us this morning from the Berkeley School of Law is Joseph Lavitt, and he's an expert on tort and liability law. He's with us to discuss his estimates on the cost of the damage in the Gulf and how much BP will be on the hook for, ultimately, for this disastrous spill. Professor, you know, we hear that this oil leak is worse than the Exxon Valdez disaster. Handicap for me what you think BP is ultimately going to have to pay.
Well, Margaret, it's not determined at this point the extent of damage that will arise as a result of this catastrophic event. Reports say that with respect to the Exxon Valdez spill, it was about 11 million gallons or 250,000 barrels. I've seen reports that the amount of oil that's been spilled into the Gulf to date is double that amount, or 22,000 gallons, 500,000 barrels. And another factor to take into consideration is that the Exxon Valdez took place in a pristine area but somewhat remote. This is the Gulf, and there is a huge economy that depends on the natural resources of the Gulf Coast.
Well, we're looking right now at some of these live pictures of the recovery effort here, or I should say the lessening of the disaster attempt here with stopping that oil leak on the floor of the Gulf. Is it ultimately going to be decided here in terms of the legal phase? Is it ultimately going to be decided upon the amount of oil that leaks? I mean, is that the crown point of liability here?
Margaret, there are several factors that go into the assessment of liability. Obviously, initially, there are the response costs, the costs of cleaning up and remediating the oil leak. The situation in the Gulf is complicated by the fact that the hurricane season may approach and force some of this spilled oil on shore. Secondly, there will be potentially fines and penalties owed under the Clean Water Act, and according to recent adjustments in the amount of those fines and penalties, if there's gross negligence, those fines can run as high as $4,400 per barrel. And then finally, there is the damage to the natural resources and the damage to the persons and businesses that operate in the Gulf. There's recreation, there's commercial fishing, there's tourism.
And there are already 130 cases filed on that front, just from local fishermen and the like.
Of course, as the oil pours out, the litigation pours in.
Yeah, it's a fair way to think about it. I mean, talk to me here about the idea that the regulatory agency itself, the MMS, that has come into a fair amount of scrutiny on its own. Are there going to be separate charges here of negligence on their part, or do you believe the law as written is in itself a problem?
Well, I think you're referring to the Oil Pollution Act that was passed immediately following the Exxon Valdez disaster, and that was signed into law by President George H.W. Bush. The law ideally incorporates a precautionary principle. That is, it incentivizes persons and companies to exercise reasonable care to avoid exposing others to unreasonable risks of harm. But the law has also always recognized that some activities are inherently dangerous, and that is, no matter how much care one exercises, these activities may still give rise to harm. And in those instances, the law has traditionally imposed a form of strict liability. The Oil Pollution Act combines those two concepts, and critics of the law might argue that with respect to any strict liability provisions, companies may view the imposition of strict liability as a cost that needs to be built into.
Professor, I've got to cut you off, and we've got to take a break. Thank you.